Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers and the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, I'm Carri Goldring, and I am here with Kristen Gross, an attorney, and she does estate planning, and we're going to talk about wills and trusts. So tell me, when do you need a will? When should someone get a will?
Okay. Well, first of all, thanks for having me back. I'm thrilled to talk about topics that are extremely important that people avoid at all costs. About 50% of the US population does not have estate planning documents in place to address what happens after they pass away. So what I would tell you is you need some sort of a plan if you have assets that you care about. Sometimes people can address or create a plan just by simply designating beneficiaries. Those beneficiaries have to be alive and have to be adults with not being under a legal disability. Disability could be minority, meaning they're too young. So if you designate, and I see that a lot, if you designate a young person, a child, as your beneficiary under your life insurance or your retirement account, that child cannot receive those assets, which would force the court to establish a conservatorship for the child to receive the assets, which they would receive at the age of 18. The other consideration is if you designate a person or you do nothing who is under a disability, like a special needs beneficiary, people who have developmental or physical disabilities that would make them unable to receive assets, either because they couldn't manage the assets, but also, and very importantly, if they receive government benefits, we don't want them to receive those assets outright because they might, it would render them ineligible for their government, their government entitlements. I know this is not where you were heading, but I just want to make that point. So back to your original question, when should you have a will? Well, having a will is a good idea if you have assets that you care about that you want to be distributed to particular people. But a will is going to require a probate proceeding for those assets that on which you don't have a beneficiary and you don't hold jointly with someone else. So if you own assets individually, the will, which is effectively a letter to the judge, is going to tell the judge whom you want to be in charge and where you want your assets to go.
Some people get confused. So even if you have a will and you pass away, everything's through probate.
Correct. A will is your ticket into the probate court. It's generally better than nothing. And let me explain what the nothing plan looks like. The state of Michigan, and I would say probably every state, but I'm not certain of that, but states have what are called laws of intestacy. They govern what happens, how your assets get distributed if you die without a will in place. When you die without a will, it's called intestate. And so that too requires a probate proceeding, but the way that your assets get distributed is prescribed by what it says in the statute. And that might not comport with what your overall dispositive scheme is.
That makes sense.
The will rather doesn't avoid probate, but in many cases it can be better than nothing at all.
And then I've heard said that if you have a will, usually the probate process goes quicker. Is that true?
No, not necessarily.
Okay.
In some cases, because your assets get distributed, well, I would just say not necessarily. The probate process is the probate process. So you have to file documents with the court. If you embark on that process in a what is called formal proceeding, and sometimes it has to be formal just because of the circumstances, then you have to have a hearing. The court sets that date. Often, with the way the courts are now, it could easily be a month or 6 weeks from the time that you file those documents. So that's something to really be mindful of as it relates to your business. People will have, they'll sell real estate and or think that they're selling the real estate under, engage in a purchase agreement for their relative who passed away. And then they find out, oh, they don't have the legal authority to actually sell the property. They have to have a personal representative appointed who has the authority. And then at that point, that could delay the sale for another 6 weeks and could result in you losing a purchaser because they don't want to wait around for the period of time it takes to go through that process.
That makes great sense. And that happens a lot. And there are many people in my industry who don't ever think to ask that question.
Right.
So it goes all the way through, let's set up a closing. And then the title company comes around and says, wait a minute.
Right. You need to fix the title, and you need to appoint someone who has the authority to transfer the title. And so that will be someone who gets appointed by the court if someone doesn't have anything in place.
Very true.
And I know you asked me this earlier, but if a person has a trust and the property is titled in the name of the trust, then their trustee can automatically step up, put the property on the market, sell the property, and get to the close, transfer the property. They have the legal authority to do so pretty much immediately when the owner of the trust passes away. So there is no delay.
And what they don't have their house in the name of the trust, but they have a ladybird deed.
Mm-hmm.
What's the difference between trust and the ladybird deed in terms of being able to sell?
So what a ladybird deed is, this is not a precise definition, but it's effectively like a transfer on death deed. Title vests in the name of the owner of the property, and typically will allow the owner to sell it, mortgage it, do whatever he or she wants to during that person's lifetime. And then at the end of their life, the deed itself prescribes a place to go. So that could be a trust, that could be an individual. If the property transfers to an individual or to the trust, all that person needs to do is file a death certificate with the Register of Deeds, and title should transfer to that person who could then have the authority to sell the property.
Okay, so one little extra step.
Correct, but a very easy one. So not a bad outcome, and can be a useful document to have in place so that you don't have to go through the probate process.
Sometimes what we'll have, and it comes up on my end more on a refinance than it does on a sale, but there's a lot of title companies out there or mortgage companies that mortgage if a home is in the name of a trust. We do at my company, which is good, but previous companies I've worked at don't. So then they require someone to deed their home out of the trust, go to closing, then deed it back in. And that empty time period is so scary.
Right.
And they say it like it's no big deal. Well, just deed it out, deed it back in. And it's such a crisis. It's a really big deal, but they make it seem like it's just sign a piece of paper.
The reasoning for it is, well, the reasoning doesn't make sense. Because most mortgages, and you could confirm or deny this if depending upon what your thoughts are, and I commend your company for doing a refi while the property vests in the title of, while title vests in the name of the trust, because having to deed it out and put it back in is an absurdity. Because most of the mortgage documents say that title should vest in the manner in which it closed. They don't want you doing, elaborate, jumping through hoops and transferring property, they generally want the owner who's on the hook for the mortgage to remain the owner.
Right.
So why would a title company be so hypocritical? I'm sorry, a mortgage company be so hypocritical and say, oh no, we just need you to convey it out, but you can transfer it back in. It makes
Ridiculous.
absolutely no sense. And you're right, it's a massive pain, and it can create problems for people who forget, God forbid, pass away in the midst of this whole process. And a lot of times it's just they simply forget. Or they say, oh, I don't want it in the trust because this was such a pain to have to do this and hire a lawyer to transfer the property out. I'm just going to leave it out of the trust.
Right.
Forgetting why the lawyer put it in there in the first place.
Right. Yeah. And I've worked at a few companies when let that happen. Yeah. I like that. I work in a really good place now where I think common sense does avail most of the time. I mean, a lot of the mortgage federal laws don't have too much common sense with them, but the ones that you have control over, I think they have a good handle on how does the title get hold? What do you do about, a mortgage and a trust and things like that? But you're right, it comes up so often. And that's the hard part. Everybody is so specific, right? Like you stick in your lane and I stick in my lane, but we cross each other on occasions, just like someone going through the divorce process, you cross over. And if you don't know what you're talking about, then you just don't know what you're talking about.
Right. It definitely, and what I will tell you, just as a general rule, is real estate doing deeds seems to, in my observation, be the most frequently mistaken or erred documents, because they seem simple. And in Michigan, you don't have to be a lawyer to prepare a deed, but people within the context of what you're describing, so refinance, divorce, marriage, those sorts of things, but also just generally, people think, oh, anyone can do the deed. I'll just draft up a quick deed, which is not a thing, by the way. It's called a quick claim deed. And because you don't have to be a lawyer to do it, people make these mistakes that ultimately can be extraordinarily costly.
I agree with you. And I have been in some instances closing on some homes where the work to figure out what's happening or what wasn't done properly and backtracking.
Yes, doing the title search. Yes.
People pass away, so it gets even more confusing depending on how far back you have to go. And it's not a fun process, and it delays everybody and everything and ends up happy.
Yeah, no, it can create a mess. And again, I know this is sort of outside the context of what you wanted to talk about, but one thing that we do a very fine job of, and I don't necessarily do a full title search. That's not really what we do. And yet we find ourselves going back and looking at title to ensure that there is a clean chain when we transfer it anywhere, to the trust, to an individual, because we don't want to see those messes emerge later on, because something was transferred in a way that it should not have been. So we try to remedy those things. And if we have to, we'll bring in a title company to take a look at it and do a title commitment, so that we have more certainty about how the chain of title plays out.
Right. It's true. All those things that people just don't really understand that are so important. That is true. So anyone who owns a home should have a will.
So what I would tell you is, if you have any assets that you want to go to a particular person and you want to have certainty and control how they get distributed, generally trusts are going to be the best way to go. I'm not always going to suggest a trust for every client, but for the vast majority, I probably am. And that is because it allows you to provide layers of protection for that individual by transferring assets to them avoiding probate if the trust is properly funded, and that's really important, making sure the assets are titled in the name of the trust. And once they receive it, the trust itself can provide a measure of liability protection as well. So yes, a will is a good idea, but a trust generally is going to be better, particularly if that person is a minor, or they want, the owner of the trust wants to ensure that if it doesn't go to their child, for example, that it goes to their grandchildren. A trust is going to make more sense in a lot of circumstances like that.
And what assets, if any, cannot be in the name of a trust?
So you're never going to change title to a 401k, to a retirement account like your IRAs. You might designate the trust as a beneficiary, but you are always going to remain the owner.
Okay.
And then there are a lot of things that I will be very cautious about transferring to a trust, like real estate. In Michigan, if we're dealing with a married couple, if they own the property as husband and wife, we call that tenancy by the entireties. But if they own it that way, then they essentially own it as one unit, subject to the death of one of them. They cannot transfer the property individually. They have to do it together. The reason that it's beneficial to have title vest in that way is because they have liability protection against the creditors of the individual. So if my husband and I own property together, if I were in an automobile accident found to be negligent, they couldn't go after my home that I own as husband and wife with my spouse.
That's true. Can I bring something up on that topic, which other people don't think about as well, is when I have divorce situations and they discuss transferring the home prior to divorce or after divorce. If they get divorced and they don't transfer ownership and do everything while they're still married, so then their tenancy entireties become tenancy in common.
Exactly.
And then all those things can attach to the house because they didn't do it while they were still married. They didn't transfer.
Correct. I've had that case happen a lot but typically the judgment will speak to how that property gets conveyed. And so if the title is supposed to, by virtue of the judgment, vest in the name of one spouse or another, sometimes that happens. Sometimes it says sell the house and and be done. But other times it might say house goes to, spouse one. Well,
right.
If that person, spouse two, perhaps passes away, never conveys the property, there is an ability to record the judgment of divorce, and that has the effect of transferring the title legally. But it does create a bit of a mess, and it is a stressful thing. And so it's important not to delay that stuff after you get divorced, and to ensure that all of the documents that are subject to the divorce, like assets, beneficiary designations, title for real estate, all of that gets buttoned up after the judgment is entered.
Right. I love when people say, oh, I'm divorced now, it's all done. It's like,
yeah,
nah, it kind of just starts that.
right. And that's hard. That stuff that's like the last thing you want to deal with.
Right.
But we've run into that too, where a person passes away and their spouse is still the beneficiary on their life insurance policy. Real estate is still held with their ex-spouse. We see that a lot, and that can create huge messes.
And right now, because interest rates are higher than what they were, it's happening a lot too, where people are saying, oh, I don't want to refinance because I like my interest rate, so we're going to keep things the way they are, right, and try to refinance a year or two down the road. And it's about, well, someone may pass away, someone might get remarried, all these crazy things that could come up in the meantime.
Right.
Save
No,
some,
it's very
right?
true. It's very true. And you're right. You bring up a really important issue, which is we're not in a climate where we want to do those refis after divorce, particularly if when you were married, you had this really low interest rate. That creates another layer of problem, of course.
Right. Yeah, it's very fun. Well, thank you for all your knowledge. Wow. That was great and
You're welcome.
impressive. And I appreciate your time for sure.
Thank you. Thank you for having me.
Of course, if anyone has questions or wants to get a hold of you, what is the best way?
The best way to reach me is to call my office. That number is 248-530-1044. Or they can always email me at Kristen, Kristen, at krglegal.com. And my office is in Birmingham, Michigan. So we're located in Oakland County. Thank you.
Perfect. Thank you. Really appreciate it.
My pleasure. Thanks very much for having me, Carrie. It was good to see you.
It was great to see you as well. Hi, I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.